Everyone, welcome back to our much awaited talk on artificial dissemination. By the way, it does create the same moral, ethical, and security risks, but we are here to talk about AI, Gen AI, artificial intelligence. Before I start and introduce our speakers, we've got an AI poll. It's got 6 questions. Whilst we're going through the talk, please could just give some thought to these questions. There's no right or wrong answer, but at the end we'll just possibly see where the thought is in the room, and also welcome to the online audience. I don't know if I'm standing over there. Am I off screen? I'm okay. So those online, welcome as well. And we are monitoring questions in the chat. I don't have a particular chat on me, so I'll be briefed by our tech team on the left there. This is a massive topic, right? So what we try to do is give it a bit of structure through our speakers here. We're going to talk very briefly. I'm just going to go through before I introduce just Daniel on the end there from my right. Is a senior associate. She holds a BCom law and LLB degrees, both with distinction. This is something quite unique to Danny. Everything she does is with distinction. From the University of Pretoria, she was admitted in 2018 and specialized in IP commercialization, brand protection, copyright management, enforcement, due diligence type work, and drafting of software contracts. Interestingly, she worked as a newsreader for Tux FM. And but despite her talent, she confesses that she's never been able to ride a bicycle. So that's Danny. She's going to just introduce us to the EU AI Act and talk about where Africa is as far as regulation is concerned on AI. We'll then switch over to our guest speaker here. We're very, very happy to have J.K. DeToy from the Good People Data Company. He's a chartered management accountant and member of the American Institute of Certified Public Accountants. He spent his early career in finance with a leading FTSE 100 company in London, working as an accountant in PPE, public-private partnership, transformation projects across the United Kingdom. Following this, he transitioned to Genius Reserve, where he led the banking research portfolio for one of the top 4 banks on the African continent. But currently, and this is where it becomes really interesting, not that the others wasn't, but he is the CEO of the Good People Data Company, a fast-growing leader in data-driven software development across a range of industries. Their work includes onboarding automation for a vast range of asset classes, employees, and suppliers, along with advanced data and software services to create innovation solutions for their clients, making use of, obviously, data, AI, and automation. In addition to his role at the Good People Data Company, he is a part-time faculty member at GIBS. We all know GIBS, one of the top 50 business schools globally, designing and delivering short courses on data strategy, helping to shape the next generation of business leaders in the digital age. He says that prior to his achievements, he was actually a bit of a school dropout by his own acknowledgements. He was only really keen on bicycles and rugby, much like most of us. And he only realized that he actually had a gift and a potential for work was when his visa was running out in the United Kingdom, and was forced to do studies to remain there. And that's led to his progression through the ranks. He's a really exciting speaker, so I'm looking forward to hearing from him. He's also ridden bicycle from Musina to Cape Town. Is that correct?
Yeah.
Beitbridge.
From
Beitbridge in just 17 days. So looking forward to.
No.
She was on the back.
It was a tandem. Yeah. Okay, so then of course we've got Verena Griffiths, no stranger to talks on AI. As a qualified attorney and trademark practitioner with more than 15 years litigation experience, her practice is focused on all forms of intellectual property with a keen interest on copyright, particularly software and publishing. She has knowledge and experience of all types of IP enforcement matters in various African territories, and advises clients on legislative measurements and regulatory matters. Verena has been involved in the representation and acted for prominent local and international clients, including Fortune 500 companies across different industries, including fashion, information technology, food and beverage, retail, and transport. She's the co-author of the 2017 edition of the copyright chapter of the Law of South Africa, LAWSA, and a guest lecturer in both LLB and LLM courses in intellectual property at the University of Pretoria. She's also recognized as by WIPR and WTR in their rankings. Apart from that and those achievements, she's a qualified netball coach and umpire. And then finally, last but not least, we've got Stephen. Stephen is, and by the way, Verena's talk is going to focus on the copyright angles and the litigation around AI and copyright. Stephen is a Cape Town-based partner, chairs the Trademark Prosecution Department, sits on various committees, including the AI Committee. He advises clients on all issues relating to brand protection, management, and enforcement. He regularly advises clients in relation to copyright disputes and has a vast experience relating to anti-counterfeiting. He co-authored the Practitioner's Guide to Intellectual Property Law in South Africa, published by LexisNexis, has been listed on an ongoing basis in world-leading trademark professionals and WTR since 2011. He holds a BCom and LLB degrees from the University of Johannesburg and is a qualified attorney and trademark practitioner. He's a member of the Legal Practice Council as well as a fellow of CIPL and a past member of the Anti-Counterfeiting Committee and Trademark Law Committee of CIPL. He was a DJ at university, tying up with the broadcaster, but refuses to share his DJ name. So added to those questions on there, we have to guess his name. He makes his own wine. So there's a fun fact about Stephen. So guys, I've gone through that. Without further ado, I'm going to hand over to Danielle to start off the conversation.
We're going to stand at the podium.
Up to you.
Can I get the clicker? Thank you. Morning, everybody. Typical morning, yeah. Okay, can everybody see? Did it change? Okay, so we've taken a quote from one of the AI policies in South Africa that we believed is very, very interesting for the purposes of this AI discussion and tying in with our Realizing African enterprise. So according to the African Union Development Agency, they estimate that AI could potentially double Africa's gross domestic product rate by 2035. So that's a very, very interesting quote. And if we could potentially harness this power, it could have massive impact on the African continent. I'm not going to delve quite deeply into exactly what AI is. I believe JK is more well placed to say exactly what it is. So basically, with AI, which is artificial intelligence, it is basically a technological project that has intelligence. So like a brain works, it takes in data, it processes this data, and then it spits out a result. An AI system is just able to do this at an immensely more speedier way than a human brain can. And as set out in the slide, how AI systems works, it analyzes large amounts of data inputs, detects patterns through algorithms, performs the task, and then learns and improves on that performance. And according to a recent Eurobarometer survey, it's revealed that 90% of people believe that robots and artificial intelligence need to be regulated and have human oversight. And this is not just because of movies like Terminator or iRobot. So the advances in computing technology are so vast, and the large quantities of data and new software is leading to rapid AI innovation. So artificial intelligence is being seen as a general purpose technology, a GPT, or more and more. And although it's incredibly helpful and the potential uses of it is across all sectors is immense, there are certain challenges that we have to take recognition of. So these include discrimination on racial, ethnicity, or gender in these systems, biases in decision-making algorithms, intrusion in private life, and even manipulation, if you think chips embedded in human minds regulating their behavior. So enter the EU AI Act. So on 1 August 2024, the EU AI Act came into place. It's the first democratic legislation on artificial intelligence. So the EU AI Act harmonizes the rules for the development, deployment, placing on the market, and use of artificial intelligence in the European Union. It also sets up national oversight authorities as well as the EU board in the EU to ensure the consistent and uniform application of the Act throughout the European Union. And it adopts a risk-based approach with respect to AI. So what this means is the higher the risk of harm to society the AI poses, the stricter the rules. So you get 4 levels of AI protection or risk levels. You get your unacceptable risk. This is AI systems that are completely prohibited by the Act, which is deemed to be completely acceptable. For instance, social scoring systems that you see in certain countries where if you have a certain score, you get certain benefits. Then you have our high risk category, which is subject to very strict requirements in terms of data quality, transparency, human oversight, and also needs to have conformity assessments. And then you have your limited risk, which is only subject to transparency obligation. Most of our chatbots fall in this category. For instance, when you deal with a chatbot like ChatGPT, it has to say that you are talking to AI. And then you have your minimal risk category, which is not really regulated, more like a code of conduct applied to it. And this is like your spam filters or your video games, which is not really a risk to society and is more just for general use purposes. Non-compliance with the Act does and could result in significant penalties. You're looking at infringement fines of up to 35 million euro. So this is plus minus 670 million rand you're looking at, or 7% of the global annual turnover of that infringer, which however is the higher. And then beyond the monetary implications, if you do infringe the Act, it could also lead to the authority withholding or withdrawing or placing a suspension of that AI in the EU country completely. And then South Africa has also then decided to follow suit and on 1 August 2024 published the National Policy Framework for AI in South Africa. So this is the first step South Africa has taken to adopt a national AI policy in South Africa. It's aimed at boosting economic growth, digital inclusion, and, well, boosting our country's global competitiveness in AI innovation. There are certain key pillars that it's based on, including capacity building for key skills and knowledge to enable workforce readiness through the aim at basic education level through to tertiary level, training programs and development initiatives. Investment and infrastructure is very important. The framework speaks to the so-called digital divide in South Africa that we're all aware of. Some of our communities don't even have access to electricity. So the need for supercomputing technologies in those areas is a little bit unfair. And funding for that, garnering funding for that. And then you have our research and development initiatives. They aim for a partnership between academia and industry and the government to achieve AI technologies and growth. They have identified that artificial intelligence can be very effectively used in the public sector to enhance efficiency and performance, but they also acknowledge that transparency and accountability will then play the forefront. Ethical guidelines are very important across all the AI policies that we've had a look at. So it's basically ensuring that the AI actually respects human rights, fairness, and avoids bias and prejudices in these systems. Privacy, data protection, safety, and security is also placed on the forefront through cybersecurity measures and risk management protocols. A governance framework is also set in place to establish an authority that have oversight over the use and implementation of AI, that it actually does comply with the legal requirements and ethical considerations. And then transparency and accountability are words that I'm sure you're going to be hearing from my colleagues today is put at the forefront. So the aim is to develop public trust in AI, not Terminator, not iRobot. You want to actually know where the output is coming from, and understand how the algorithms work to come to the outcome or decision-making process. Honestly, I've read through a couple of these frameworks now, and the South African framework is a little bit disappointing. All of the stated indicates it's very vague. There are no implementation steps. It is a framework, so I'm going to give it some leeway. But if you do read other countries, especially in Africa, national policies, it just falls a little bit. It's a miss. It's a miss. So we're going to be looking at that. So turning to South Africa, to Africa, I'm going to leave that there. So we, or at least I, am not aware of any legislation or formal regulations that regulate AI in Africa across the 54 countries. However, there are certain countries that have made inroads in establishing at least a policy or strategy. Starting with, I'm only going to be looking at some of these. So starting with OAPI, which is the region of French-speaking countries in the north of Africa. So OAPI, no legislation, no formal regulations, but there have been ongoing discussions around the need for a regulatory framework to recognize and regulate data quality, cyber crimes, and of course, ethical considerations with the use of AI. There has been talks in Yaoundé in 2024 in June to recognize solutions for these problems, and Cameroon has also issued in August 2024 a call for the expression of interest for the pre-selection of a firm to assist government in establishing a national AI strategy. Nigeria, I'm very impressed with Nigeria. If anybody wants stats on AI, definitely go and read the policy that's currently in the draft form. So the Federal Ministry of Communications, Innovation and the Digital Economy has published a document called Draft National AI Strategy 2024 that sets out how Nigeria aims to harness the transformative power of AI with collaboration efforts. The Federal Ministry has also looked at implementing bills in Nigeria, including the control of usage of AI in Nigeria in 2023, as well as the establishment of a National Institute for Artificial Intelligence and Robotic Studies. It's yet to be seen if they'll be able to implement it. Then in Kenya also no legislation or regulations in place, but it has indicated that it wishes for a soft approach to a national AI policy. So what that means is they want a national strategy or policy, and they don't want it to be enacted via a local law or an act of parliament. So it is currently working with stakeholders to develop a national strategy or policy. And it's currently being prepared, and it's anticipated that this will be released in this year still. The Kenya Bureau of Standards has also issued it's a long one. The Kenya Information Technology Artificial Intelligence Code of Good Practice. So this is in draft form. This is in draft form, and it hasn't actually been published yet, so they're still working on it, and that's aimed to regulate the responsible development of AI in Kenya. And then, right on the far side, the Independent Robotics Society of Kenya has issued a document entitled the Robotics Institute of South Africa, Institute of Kenya for Artificial Intelligence and Robotics. So this thing has been published, but not in the Kenya Gazette, which is where all the other bills are published. And it hasn't received any support from the government, and it has actually been opposed by key private sector stakeholders. So it's unlikely that this will come into effect. Then Rwanda. Rwanda is, in my opinion at least, in the forefront when it comes to AI in Africa. There is a national AI policy in place. It's very impressive. They set out exactly what they aim to achieve with implementation steps. It's a very good read if you are interested in reading something like that. So what Rwanda states in its vision that it wants to become the hub of AI research and innovation in Africa globally through collaborative efforts. It recognizes the need for the nurturing of local AI talent, innovation and development, and as well as the responsible and ethical use of AI to promote the AI services in Rwanda. It's built on 6 pillars, which it's a little bit confusing, but it's 21st century high AI literacy and skills. The infrastructure and development is also placed on the forefront. And then there's also the adoption of AI into the public sector and the benefits of the adoption of AI into the private sector, which is listed as 2 separate factors that they're looking to implement. And then as well, a robust data strategy and ethical considerations is placed as one of the most important things. So it's very exciting, and we'll see. It looks like if I had to rank them, it's Rwanda, Nigeria, South Africa. And then for Zambia, also no legislation or regulations in place, but Zambia is working with the Tony Blair Institute to actually formulate a national strategy on AI, and it's also collaborating with the European Union to set up a startup bill, which is aimed at fostering and investing in technology and entrepreneurship. And then lastly, we have Mozambique, also nothing to bring home on legislation on the regulatory front, but it has been mentioned in the 58th edition of the Maputo International Fair that the benefits of AI are imperative, and there is a need to put a policy in place. And it was in a seminar entitled Artificial Intelligence, the Benefits and Challenges for Mozambique. So in a nutshell, that's what we're looking at Africa currently. And this doesn't mean that AI isn't being regulated in these countries. You could still look to local laws if you have AI issues in their countries. So these are general and specific laws like your Copyright Act, which you can't reproduce without authorization the AI that you are using. You've got your Data Protection Acts in each of these countries, as well as your Cybersecurity Acts. And then as a last resort, you could even look to Consumer Protection Act in some of these countries relating to technological products. Yeah, in a nutshell. Thank you.
Well done. Right. I think we should just move swiftly on. JK, the room is yours. Go for it.
I'd bring it into a slightly more practical realm, and I'm going to throw a couple of curveballs your way, just to start thinking about how you actually need to apply all these wonderful frameworks to the clients and stuff that you might be dealing with. So first of all, we started looking at drafting appropriate AI policies and contractual clauses and agreements. We are seeing quite an emergence of third-party AI suppliers coming into the market. I mean, all of us would have seen some of the big names. We would have seen the Isazis, all of these companies operating in Johannesburg, building applications on behalf of organizations who then build products out of that, which they then end up taking to market. These are just some of the key considerations to keep in mind when contracting either a corporate client or an Isazi within that context. So the first of all is truly understanding the scope of services. And I'm actually going to do a small experiment with you guys. I want all of you guys to close your eyes, and I am going to describe a house that I want you to design for me in your mind. So what I want is, first of all, I want a beautiful lawn as you approach this house. I want a beautiful big double oak door. As you walk into the house, I want it to open up into a double-story, double-height ceiling with 4 double bedrooms, all en suite, a big kitchen in the middle of the house, and the house has to cater for my full South African family. Right, you guys can open your eyes. Perfect. Ask you, where did you put the doggy door? Exactly. How many cars did you cater to park on the driveway, as an example? Yeah, I've got 4. And the problem is, within a lot of these clauses and not truly understanding the scope, is we end up with scope creep, and we end up with a huge amount of ambiguity. And it is critically important for us to understand the true scope of work and the expected deliverables with the service level agreements. If that front door falls off, exactly what happens within my house? How long does that actual service provider have to come and fix it up? Secondly is data privacy and security, particularly the compliance and the regulations, but then also the data ownership, the usage rights, and the protection measures which those companies are taking. Typically, when companies, especially some of our clients, have actually contracted organizations like Isazi, their ability to audit what happens with the customer information, where that information gets passed on to, and who actually owns a lot of the information and the derived information is extremely vague. And we need to make sure that we truly understand the data flows, the organograms, the data access, and the security around that as well. Do any of you guys actually make use of third-party AI providers at this particular point in time to build algorithms? Have you had a look at the data processing agreements and the current security measures? The problem is the leak comes within a third-party data provider. Your client's making use of that service is liable to a customer that sues them on the back of his information. What happens? So these are some of the practical consideration. On intellectual property rights, I'm not sure how many of you have actually checked how much of the intellectual property remains as legacy within the AI provider, within the person that's actually building the algorithms versus the company or the client utilizing them. But more often than not, the IP will reside within that particular provider. So they will argue that to the hilt and back. When we started the Good People Data Company, we offered 30% equity of our business to one of the large AI companies in Johannesburg in order for them to build our technology. The entire deal fell flat because they refused to give the IP to the Good People Data Company for everything they developed. What they would typically do with that technology is they would keep it in-house, they would repackage it, and then go and sell it to all the competitors on the back of the funding from your clients. So you need to make sure that is very, very clearly stipulated. And that would typically come in with a scope of services and truly understanding the product descriptions within that documentation as well. Liability. I have actually got 2 use cases that I want to take you guys through at the end in real life examples where things have actually gone wrong. Where does the fault line sit if something goes wrong within an AI application? And I'm going to make particular reference as well to black box AI and machine learning models, where we do not truly understand what the mathematics is doing. We can see that the model works and we can see that accuracy and output is improved, but something goes wrong. What then happens in a practical sense and from a business and a contractual point of view? Ethical use and compliance. Again, one of the cases and stuff that we'll be discussing at the end is looking at recruitment technologies and where AI was used for companies like Amazon, Amazon Web Services in the US, and how those models are actually trained. How do we ensure that when we are training these models and we are writing these contracts, how do we reduce bias within those models and actually build a fair and ethical product? Just to briefly highlight, Amazon Web Services designed using their historical data and the success measures, how they find success to actually build a new AI model for recruitment. The model went fantastically well until they realized the data they had used to train that model favored white males, and it started eliminating and blacklisting individuals of color and females in the entire recruitment process. Because historically, what had worked was they had recruited a particular demographic and the machine said that is good. How do we cater for that within our agreements? And again, who is liable in the event of an issue arising in the back of that? Termination clauses. I think those are relatively straightforward. What you would need to really keep in mind, again, what happens with the data once your AI model is being deleted? Data moves within organizations, moves between individuals, sometimes ends up on third-party service, third-party applications. Do we know where the data is sitting? Do we actually monitor, like within the security and the technology compliance layers, do they actually have the ability to see who has access to that data at which particular point in time, for which particular purpose, and what happens in the event of a termination, and are we keeping track of that? Again, coming down to your detailed service descriptions. Sorry, my screen has died on the side. There we go. Perfect. Cool. And then just a couple of summary points on best practices for negotiating our contracts. First of all, involve your business teams. You would need to have a cross-functional team of individuals. Your business guy is going to have a very, very different idea of what he wants from the product, he's probably going to be looking at revenue lift, open market. Your technology guy is going to have a very different view, and the legal teams are going to have a very different view. It's important to get every single one of those stakeholders involved when drafting these contracts to make sure that every single one of those components are basically catered for. Due diligence on your AI providers. Please, 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 guys, there are phenomenal companies. We've just gone through a capital raise. You should have seen the amounts of audits that happened on our organization in order to see where our data comes from, where the data is hosted, how the data is secured. Companies are notoriously bad at deeply auditing any kind of service provider or entity or where that end customer data actually ends up. So if anybody is interested, I can pass a list of those companies on to Darren. Make sure that you understand what is happening to your client data and everything is clearly documented and contracted for. And then establishing mechanisms for ongoing performance monitoring and audits. Again, a lot of very cool technology tools which monitors access controls, which sees which IP addresses, in other words, which devices are accessing your data, what they're accessing it for, and you need to, again, make sure, particularly where there's consent and sensitive information regarding, all of us know, your sexual orientation, your health data, your financial data, anything deemed sensitive, making sure that we actually have mechanisms and contracts in place to monitor usage of data and how the data is moved between different divisions and organizations as well. Then intellectual asset management and AI. Again, it's a pretty simple framework that I've just put together, just again to stimulate thought, just to make sure that you've got a couple of key areas you may not have thought of covered in your legal agreements when you're going through those with clients. First of all is the identification of intellectual assets. Deeply understanding and truly actually understanding the data that's driving the algorithms and those models and stuff that are being built. Secondly, the algorithms. Just this morning, I was chatting to somebody and they had a client. The client had built a biomedical piece of technology that had black box methodology. They knew the technology worked. They couldn't understand why it worked. Now, the biggest problem we have is the moment that you need to go to court and you say, this is my client's IP. And the judge goes, what does it do? You know, what is, and you cannot explain it, then again, you open up the door to different kinds of challenges and stuff. So it's very important, deeply defining what the product does and trying to understand as far as possible how it does it. Again, protection mechanisms. I think, Darren, you can dig into those a bit later. But again, most of you guys are from the legal fraternity, would understand the legal protection mechanisms. Compliance. I've got a list of about 15 different tools which will help you guys monitor online the use of copyrighted images, plagiarism on text, and a whole bunch of other stuff where you can now actually put a digital signature on pictures. If your pictures or logos are distributed anywhere on the internet, the algorithms will pick it up, and you can basically see that the stuff's being used, and you can take recourse. I was sitting at a Christmas lunch, Christmas Day, having a fantastic couple of wines, fantastic lunch, and next thing my phone goes off, my phone goes ballistic. My CTO phoned me to tell me that one of our pieces of code had ended up on a public repository on the internet, and it had included some of our sensitive passwords and code. We, as a credit bureau, have access to over 60 million people's data in South Africa. You can understand the stress I had in that particular moment. Using these technologies, within 4 minutes, we were able to identify the issue, block the code, and switch it down. Within an hour, the employee was fired from our organization as a result of these technologies. In a new digital age of artificial intelligence and quantum computing on its way, we cannot afford to not have these protection mechanisms and the monitoring in place, because things are about to get a lot quicker and a lot worse for those that do not actually keep up. Then establishing cross-functional intellectual asset management teams. Again, make sure that the entire business is involved, that you involve the relevant stakeholders, because every single person will have a very different interpretation in terms of what intellectual assets mean. When we went through our company valuation, I had a conversation with my dad. My dad's an old school insurance broker. He lives in Zinien, typical farm guy. And he was like, JK, you know, so what is your company valuation? And I gave him a number and he says, I don't understand. You don't own anything. My dad's used to physical investments. My dad's used to, you know, seeing a house and seeing a car and seeing a road and seeing a truck. And he's like, what do you own? So I'm like, here's my website. And he's like, I don't understand. the definition of intellectual assets and how it pertains to different types of users, and the documentation and the identification becomes absolutely critical for any of your clients wanting to do anything with those particular assets. And it's just making sure that you have all of your intellectual assets properly documented and a flow put in place for that. Again, on the tools and technologies to monitor the use of your intellectual property, that same list of 15 companies I can pass over to Darren. Training and awareness programs. The one thing we did very, very well after Christmas Day was making sure that we started advising our staff, and every single Friday at 2 o'clock in our weekly reviews, we tell them what is deemed company assets, what can happen with the information and the data, what information can be disclosed, what cannot be disclosed, and we started basically documenting those. We then set up a tracking tool, which we built internally, and every single week, every single one of our staff members are measured on 27 different KPIs to make sure we continuously reinforce data security, user controls, password controls, use of data, and every single other piece around regulatory and data handling. And then, yeah, continuous review and improvements. All of us basically need to periodically assess our processes for effectiveness. Every single time a new piece of technology, a new website is launched, things will change. With AI, with the emergence of new white label technologies coming out, we can spin up new instances in 5 minutes for new customers. Things change drastically. You need to make sure that you stay on top of it and that you advise your customers in terms of the technology and scalability, especially when it comes to the artificial intelligence businesses and infrastructure. Again, the IAM implementation in our organization is something that I went through earlier on my Christmas Day case study. I've got 2 case studies here. Obviously, I can't give you guys all the answers, but it's going to start provoking thought in terms of the use of data and how artificial intelligence kind of blurs the lines. So I'm not sure how many of you guys have ever been to the US, but you've got Walmart and you've got Target. Target started looking at the buying behaviors and patterns of particular individuals to pick up changes in lifestyle or any notable changes. So things that we typically monitor within our data is changes in credit profiles, potential indebtedness, probability of defaults, and we have certain indicators, and using machine learning, we start noticing if something changes on a particular data string over time, what is the impact on other data points? And Target used that exact same methodology in tracking people's spending behavior. And one thing they were looking at was actually people getting pregnant and changes in family composition. So in the US, there was a family and the daughter started getting marketing materials around pregnancy and baby products. Of course, the dad went off at Target for basically saying, listen, why are you promoting teenage pregnancy and everything else? Only to find out the daughter was in fact pregnant. Target had basically noticed her changes in shopping behavior, picked up that she was pregnant, and took a proactive marketing approach. When it comes to artificial intelligence and how all of this works, where does the fault line lie? Because all of a sudden, the daughter's personal life is thrown upside down. She hadn't told her dad about the pregnancy. Target used the information and resource at hand. This is one instance. And again, data sensitivity. What are we sending to our customers at which particular point in time? How do we blend data to potentially hide sensitivities within particular information sets, etc.? And again, I think it could be a whole different topic of conversation. Second one, and I think we're going to start seeing a lot more of this, especially now as Uber is moving to flying drones. I'm not sure if you guys have seen. But in London, they're also now, Amazon is using drones for deliveries within the M25, so in and around London as well. What happens in Tesla, we had autopilot cars. I'm not sure if you guys actually saw the pictures, but in California, a brand new Tesla, one of the Google employees crashed into a wall. Car burns out and the driver died on the back of autopilot technology. Again, for consideration, who is liable? Was it a third-party AI providers? What security measures were taken? And then how do we actually ensure that we have proper real-world testing that is wide enough in order to ensure or to try and mitigate any of these types of risks? Then just key considerations just to close. Ethical AI implementations. Companies must consider the ethical implementations of AI system, ensuring they do not cause harm or infringe on individual rights. Data quality and bias mitigation, utilizing diverse and representative data sets is crucial to prevent biased outcomes. In 2020, I'm not sure how many of you guys saw, but Zoom actually started with all these really fancy backgrounds and stuff that you now get in Teams and on all these other really cool applications. Any person of color was automatically eliminated from that picture and blended into the background. Can you imagine the damage and the market cap impact? You could wipe billions off a company's valuation on the back of one of your AI tools going to market when it hasn't been tested for bias. How do you actually handle that? And how do you treat that within the law fraternity? Transparency and explainability. Again, in a lot of instances nowadays, and I see it with, so I've got 104 software developers sitting in an office here in Sandton. The youngsters will go into ChatGPT. All of us have been on ChatGPT, and we now have the paid versions, and it's actually pretty good. But what's happening now is our youngsters will take small pieces of code, and then they will put it into ChatGPT, and they'll basically say, fix the bug, find the bug. Sure, ChatGPT gives a result. Our youngsters see the code works. They don't understand why. It's becoming a massive, massive issue. Our ability to explain technology, to explain what the technology does, particularly pertaining to end customer information, is going to become more and more important, especially as these models are now starting to grow. Robust testing and validation, again, making sure you've got proper testing processes in place before releasing any piece of technology to make sure that everything is completely fit for purpose. Regulatory compliance, we know that regulation is starting to catch up. Danielle, you mentioned earlier in terms of South Africa's regulation being vague. If the regulation is vague, how are we actually handling that? How are we protecting our clients? But I do think regulation will continuously play catch up. One of the areas that I spoke to one of the other guys about earlier as well today is we can regulate big companies. It's very difficult for us to regulate an 18-year-old sitting in his room in Ireland, busy building artificial intelligence models that could basically impact a whole bunch of other people or potentially our clients. Just something to keep in mind. But again, regulatory compliance, the regulators are trying to catch up, and we're starting to see this every single day. Papaya is an instance, NCR is trying to catch up, and now we've got some other stuff coming as well. And then customer communication, again, in line with Papaya. Customers need to know what's happening with the data, what it's being used for, how it's being processed, ensuring there's no further processing. And within the context of AI, trying to figure out where does an infringement on the person's right to privacy lie, particularly in relation to things like the target case. Yeah.
And there's a lot of, geez, I mean, this is it's quite profound. I mean, I think it's so nice to hear it from someone in the game, right? As opposed to a lawyer speaking, you know, obviously there's value in that, and certainly not to detract from your talk and the upcoming talks, but really from our perspective is wonderful to hear it from, you know, just the scale of this. It really is enormous. I think just in the interest of time, I'm sure there are questions. Please keep them. Let's move on to the next topic, which is also a very, very interesting topic. I just want to just add something about the Good People Data Company. Can you just it's non-AI related, but I just think there's a reason why it's called the Good People Data Company. You just couldn't explain on that.
Yeah, so we have a quite a well-known technology fund that invested into our organization when we started. They're called the Empire Partner Foundation. They've got 3 different tech funds. We were the fortunate beneficiaries of one of those funds when we started on our journey. One of the key pillars was that we had to develop African technology using South African resources for the benefits of Africans. And one of the key mandates was to say, how are we going to use technology to empower South African youth? So one of the first things we did was we partnered up with MICT CETA to try and unlock some funds. Fortunately, the foundation was successful in getting some money. And we started off with 6 interns who we then basically took, not from top-tier universities, we took the 2nd and the 3rd-tier universities, particularly for individuals who came from disadvantaged backgrounds. We started the individuals on a stipend plus a small salary top-up to try and get them into a livable wage. Some of those interns started, they were living in the worst of the worst conditions in places like Soweto, in Alex. And what happens is every 3 months on the individuals who now hit their targets on those 27 different KPIs, every 3 months they get a salary bump. So every 3 months the salary goes up a little bit. And the first month everything comes in and you smell noodles in the office. And then, you know, like next thing you notice, you know, one guy wearing a new pair of shoes. And then as the year progresses, you notice proper food coming into the office. Some of the youngsters now are the first in their families to move out of the township in generations. So yeah, we've managed to now have 104 of those youngsters who we actively employ. We've actually managed to retain most of them. Every once in a while, like yesterday, we had six of our guys targeted, and then they immediately run to us and they say, "Hey, these companies are trying to recruit. Check what they're doing." But yeah, we've actually managed to build all of our technology on the back of youth development within what is now known as our innovation campus. As part of our capital raise, our organization is now basically spinning the innovation campus out as its own standalone entity, and it will continue to grow, supporting companies like PwC and the rest who are now actually, and Deloitte, who are now quite actively involved in that initiative as well.
Oh, very good. I mean, realize African enterprise right there. So,
sorry, Darren,
yes,
can I just say, we always believe that there's a war for talent. I don't believe there's a war for talent. I believe there's a war for proper development. The disconnect between corporate South Africa and I think our youth and the talent of our youth is vast. We just need to find the mechanisms to start, you know, basically closing that gap. And what we've basically you know, started seeing is how talented some of our youth are. One of our clients is a company called Betterbond. Some of you guys might have known of them. But what we basically did was we used data and technology to automate and to digitize your bond application process. We took that workflow from 5 days to 4 minutes, 20 seconds, and we now process between 20 and 30% of South Africa's bonds on a technology platform that we launched middle of last year. So went into pilots in April, in July. We've passed nearly 40,000 bonds on that application in the last year. Our lead developer is 23-year-old black female, and she's phenomenal. I wouldn't change her for the world. So the skills exist, the talent exists. We just need to close the gap between technology enablement and where the market currently operates.
Which, by the way, apart from the Realize African Enterprise, does just think about that first question, whether regulation is good for that, more of that to happen. Is it a deterrent or is it good? Because the funds, are they local funds or are they offshore-based funds?
No, these are local funds.
Local funds, okay. Anyway, that's thank you very much, JK. Thought-provoking stuff, inspiring stuff, actually. Verena, over to you.
Thank you, Darren. Am I on? I have to follow that. I didn't realize I would be standing before I chose my shoes, but then again, without it, I'm not going to be able to see over the podium. So moving on from my challenges to the challenges that are being posed by AI, and I'm talking about IP legal challenges. We see these challenges continue to be focused on two main aspects. The first one, of course, being the question around ownership, when especially generative AI tools are used and content is generated, who owns that content? And on the other hand, are questions around infringement. Now, those infringement questions arise both on the input data, so those are the data sets that are used to train AI models, as well as on the output content, and that is, of course, the content that is generated by the AI tool. Could there be any infringement concerns there? The questions still very much outweigh the answers, but we are seeing these examples increase in numbers. And interestingly, we're also starting to see contradictory decisions coming out of some of the jurisdictions. So I will just be touching briefly on some of the developments and the more recent examples. Starting with the input content, so now we are looking at the data sets that are created and used to train AI models. Last year, I did discuss the case involving Getty Images and Stability AI.
That was the first of its kind. It was launched in the UK. Getty Images sued Stability AI, which is the developer of Stable Diffusion. You may know Stable Diffusion as an image generator. Sued Stability AI for copyright infringement, and in its lawsuit, it alleges that in the training data for Stable Diffusion, Stability AI included 12 million images owned by Getty without its authorization. Therefore, the claim is made that that amounts to copyright infringement. And since then, Stability AI has filed its defense. It is, of course, denying all claims of copyright infringement. And in doing so, it is differentiating between images that were generated following text prompts by the user and images that were generated following a provision of an image by the user to create another image. In doing so, recognizing that where the user provides an image and asks the AI tool to then provide something substantially similar, there could be an infringement claim there. But Stability AI lies or puts the liability for that potential infringement claim squarely at the feet of the user. Alternatively, Stability AI is relying on an exception, a very specific exception, which relates to prestige, and it says that the extent to which it used copyright protected material in the training of Stable Diffusion, it only did so to the extent necessary to allow for the creation of a work for prestige. Nowhere is there a denial of the use of content that was protected by copyright for the inclusion in the data set used to train Stable Diffusion. Since Getty also, we've seen several cases in the United States that were filed by authors or groups of authors, all alleging that the materials used to train the different AI platforms included material that was copyright protected without the author's consent. Initially, those lawsuits lied against the major players, of course, OpenAI and Meta, for the training of ChatGPT and Llama. More recently, there has been a case by a group of newspapers, including the New York Times. Same form of claim that the material used is copyright protected and no authorization was provided. And that one is against Microsoft for the training of Copilot, as well as OpenAI again for ChatGPT. The most recent one is by a group of major record labels, so that's Universal and Sony and others, claiming that the creation of the AI generator that takes text prompts and turn it into audio files, Suno, similarly infringed copyright when it was trained on data sets containing material that was copyright protected. Now, all of those examples, you can here include the same claim or very similar claims in that the data, the material that's used in the data sets that is used to train the AI model contains copyright protected material without the consent of the original copyright owners. And all of them are still pending. The jury is out and they probably have some way to go before we will see any outcomes. However, very recently in Germany, as recent as last month, a German district court issued a decision on a similar set of facts, or at least a similar claim, that an AI platform developed by Lion was trained on a data set that included images that were subject to copyright protection and without the authorization of the owners. There, the German district court upheld the, dismissed the infringement claim. So it found that the inclusion of those images in the training data set did not amount to copyright infringement, but it did so by applying a very specific exception. And that exception relates to data mining for scientific research purposes in a non-commercial setting. So you can hear that it's a very specific set of facts and a very specific exception that enabled the court to dismiss that infringement claim. And probably on that basis, this case can be distinguished from the earlier examples. Also in China, before the Internet Court of China, there was a case involving a cartoon character called Ultraman. Ultraman is apparently quite a decorated cartoon character. And it was a case involving the infringement of the original Ultraman character when a user prompted an AI image generator to create a Ultraman related content. So the user intentionally prompted for material that is substantially similar to the original content. And the court in that case found the AI developer guilty of copyright infringement. Interestingly, it did so based on the images that were created by the AI tool and of course prompted by the user, but the court used that to find that it must follow that the AI tool was trained on original content that was then therefore reproduced within the data training material without authorization of the copyright owner. So there we saw the claim for infringement upheld against the AI developer, but it does bring me to the output content and the fact that there is similarly risk in the creation of material through generative AI, and that amounting to a case of copyright infringement, as the Ultraman case well illustrates. Of course, the prompting matters. If you have a user that is intentionally seeking content that is substantially similar or identical to existing material that's protected by copyright, the infringement risk is certainly real. And we can contrast that with circumstances in which you are wanting to create or generate more generic material, for instance, using an audio generator to create background noise in a busy restaurant. We can definitely distinguish those from one another, but the bottom line is the risk for infringement is there. And the question, of course, if it is there, who could potentially be held responsible? Most legal regimes, if we talk about copyright infringement, makes provision for liability against the person who's either committing the infringing act or the person who causes the infringement to be made. So we can see that there's definitely a risk for platform liability to the extent that these platforms enable and allow users to commit acts of infringement. But at least those jurisdictions that make provision for computer-generated works, like we have in South Africa, and where an author is identified for works of that nature, I think it's definitely arguable that there's a risk to a user too, where the tool is used to generate content that that infringes copyright. Then just outside of copyright infringement, it doesn't, there's a real risk there, as we can see from the examples, but it doesn't end there. It is depending on the data set on which a particular AI model has been trained, there certainly is risk for infringement of other forms of IP rights, such as trademarks. It can happen that content is generated that potentially contains trademarks of third parties, or even confidential information, other proprietary information. And so too, when you are engaging with these models, and in particular the open models that save and digest information, you run the risk of disclosing and disseminating confidential information of yourself, of your employer, of potentially disclosing trade secrets. So it is very important to be very careful to understand the technology, the model that you're working with, and its risks. So those are the risks insofar as potential infringement are concerned. On the other hand, on the output content, the other significant risk is the fact that where content is generated using a generative AI model, that the user may not own the content that is generated by the AI. What has proven to be or to create the greatest obstacle in assessing this issue is the fact that in using generative AI to generate content, there is no human author. There's the user who provides a prompt, and then JK referred to the black box system where we almost don't understand what it's doing, and then it generates content on the other side. There's no real in the traditional copyright sense, human authorship in terms of creativity or intellectual input and so on and so forth. So the absence of a human author is what has led to some of the outcomes in these cases. Again, last year I did touch on the Zaria of the Dawn example, which is a case that came before the US Copyright Office, in which the author used an AI image generator for all of the artworks in a comic book, then applied for copyright protection registration before the US Copyright Office. And the US Copyright Office was not convinced that what she had done, and she had explained in her application as involving hundreds of thousands of prompts until she arrived at images with which she was happy. She even used Photoshop to make some slight changes to the images. But even so, the office was not convinced that what she had done was enough to consider her to be the author of the artworks. And so copyright protection and registration was refused in that case. So too in the US, the district court in the now infamous Darbus case, which held that in the absence of a human author, there can be no copyright protection. So the situation in the US seems to be pretty clear that you need a human author to be involved in the creation process before copyright will be recognized or copyright protection. However, again, if we move to the east, before the Chinese Internet Court, fairly recently there was a case of copyright infringement, but the work alleged to have been infringed is the one to the left, was an image that was entirely created by AI. And a blogger then created the images to the right, published them, and that gave rise to the copyright infringement claim. The first question then, of course, being, well, can the image originally created by AI be protected by copyright at all? And in that case, the court held that indeed it can, that what the author had done, the user of the AI tool, is no different to using a tool in any other creation process. So the user's input was held to be enough to satisfy the requirement of originality under copyright law. Then staying with the output content, but not so much copyright focused, an issue that has enjoyed a lot of attention, which is around the creation of deep fakes, the use of voices, the use of images and likeness, and so on. We have various famous examples, which is the song of Drake and the video of Morgan Freeman and the Pope in his bomber jacket. We have not yet seen litigation on any of these issues, but there are some examples. Perhaps a lesser known example involved an illustrator that works for Disney, who of course has a very particular style that lends to the images that is used by Disney in its films. It's quite recognizable. And what happened was an AI model was built that was trained in the style of Holly Mangert. So they used both her images as well as her name as the identifying prompt, and a user could then call up images in the style of. Now, your own artistic style or other personality traits, your voice, those are not elements that are typically protected under copyright, or in fact, they're not protected under copyright. But that is not to say they're not protected at all. They have been held to form part of your right to personality. And your right to personality includes your right to privacy, dignity, as well as identity. In South Africa, we had the case of Basetsana Khumalo, where her image was used in an advertisement commercial without her consent. And the court there recognized and upheld this right of identity. And it held that it includes or extends to your image, but not only your image, your voice, your other personality traits, your handwriting, and potentially even your artistic style. So it very much the risk is greater, put it that way, where the use is commercial use in a commercial setting and without authorization. But it does mean that where content is created that uses a person's image or other personality trait that is recognizable, such as a voice, maybe even an autistic style, there could be a risk there that it could amount to an infringement to the right of identity, to the right of personality, and therefore, again, a risk area in content generation if you were to intentionally seek out something similar to. You could find yourself in a red zone area. The takeout then, unfortunately, at this point in time, is that as the generative AI tools increase in their capability, it does appear to be the case that so do the risks. They appear to be going hand in hand at this point in time when we're talking about content generated and specifically using generative AI tools. However, that is not to say they don't have a role to play. That is not to say that they can't be used in a way where even these risks can be mitigated. And that was well illustrated by an advertisement that was created by the Coca-Cola company that was very heavily punted as an AI-driven advertisement. But when you consider the creation process behind that advertisement, you will see that the AI tools were used, but the way in which they were used were to supplement and enhance the human creativity and the human creation process, and not to replace the human creation process in order to enable them to retain the measure of exclusivity if it is necessary for you to own the right in content, and if it's necessary for you to be in a position to exclusively exploit on a commercial level, then you need to take steps to ensure that you are in a position to do so. And by using the tools to provide the benefit that they can provide, which is to reduce time, reduce costs, and enhance human creativity, by all means, they are there to do so. But it is always necessary just to keep the risk in mind and make sure that you mitigate them where possible. Thank you.
Brilliant. Thank you very much, Verena. Another excellent talk. I'm going to move swiftly on to Stephen, last but not least, just to give you an insight into the firm's latest thinking on AI. Over to you, Stephen.
Thank you very much, and good afternoon, everybody. I don't know about you guys, my brain is mush right now. It was brilliant. I thought it was a really good talk, and I think a lot to think about. Mine is not as impressive, like technically speaking, okay? Mine's more of a practical discussion to tell you guys what we're doing, how we're trying to find our way as a law firm through this quagmire of AI. And let me ask this question. Who of you have downloaded ChatGPT on your phones? Who's used ChatGPT? Okay, a couple of people. Can you guys remember the first thing that comes up when you say download and you double click and it looks at your face? The first thing that comes up says, welcome to ChatGPT. The information or the answers we give you may be incorrect, and we may share your personal information. Welcome. Okay? These are two of the biggest problems that we face as a law firm, because obviously we are looking after, well, your information in many cases. So there's a picture of that little thing which comes up. I downloaded that on my phone and had a bit of a chuckle when I had to click sure, I accept. My picture is probably floating around on the internet as we speak. But for us, really, those are the two big problems. The first is that how do we ring fence our clients' information within the firm? How do we ring fence our clients' information from our other clients' information? Even bigger problem. Sometimes we act for competitors, and you'd have to make sure that that information stays where it's supposed to be. And then how do you guarantee the veracity of the information which is given? And this is something which we've realized very quickly AI is not great at. Well, it's getting better and better, and obviously the more it's trained, the better it gets, but it does make mistakes, okay? I tried to create an avatar for my talk here today. I was a bit sick over the weekend, wasn't sure I was going to make it. So I put in all the information, and it kept creating this tall, dark, and handsome guy. And two of those I'm not, sadly. I'm glad somebody got the joke. Right, we all agree AI is great. We don't want to be left behind. What are we going to do? How are we going to treat this? Okay. As a firm, we've looked at AI in the legal space, and we've tried to figure out how we can use it. There are a couple of different things that really jump out at you when you start searching for AI on the internet. And I've listed the 4 of them. The first one is really where we are at the moment, and this is not really Gen AI, okay? I'm talking automation and bots, and this is something which we certainly use in Adams and Adams a lot. I checked yesterday, we currently have 499,754 files active. There we go. So huge amount of data that we have to look after and that we have to try and manage all the time. And bots and automated processes help us a lot. They help us to do stupid tasks, to save emails to the correct file, to check registry data and compare it with our own data to make sure that it's correct. And if there's a disconnect, to see maybe the status has changed on the registry side and we haven't received a notice. This happens. And then to alert us internally so we can report to our clients. We use it for all kinds of automated processes like that. We're also often asked to take over large portfolios of trademarks. And in that case, we like to use automated processes to firstly capture that information, make sure that it's captured correctly, and then to cross-check it against the data that we have available to us. Now, these processes, sometimes it's a bit of an ebb and flow, because I'm sure some of you guys may have noticed CIPC was recently hacked. So they've upped their security levels quite substantively, which meant for us, it's a lot more difficult for our bots to access that information, but it means that we have to go back to the drawing board and look at how we do things. But certainly the first step, we're already there. And from an AI perspective, this is not one that causes a problem for us because it's using only our clients' information internally. It's not sharing it. It's not putting it out there. And really, it's just making sure that the information is correct. Okay. The second one that we're starting to look at now, and which is quite exciting, is contract management and contract analysis. And a lot of the AI which is available is really good at this. You get programs like Harvey AI, where you can feed a contract into it, and you can say to it, tell me whether this agreement has a bias towards, say, the landlord or the tenant. And if it's the tenant, change it so that it's more has a more landlord-focused bias to it. I mean, that can save you a huge amount of time. You can also ask it to look for specific clauses in the agreement. Really, really long agreements, you can ask it to look for the indemnity clause very quickly and to find it for you. So I think from our perspective, if we're looking at tools that we can use going forward, this will be the next step for us. But I use the word tool very carefully because AI for us really is going to be a tool. We have to treat it, I think, if I can put this in a framework that everybody here would understand, we'll treat it like a really good candidate attorney, okay? It's going to go out there and it's going to do a lot of the really crappy work that you don't want to do yourself, and it's going to produce something for you, but by golly, you're going to have to check it. You're going to have to check it carefully, okay? You can't just rely on what it produces. I've got a client at the moment, I mean, this has got nothing to do with the slide, but I'll just mention it. A client who approached me yesterday, in fact, they used an AI generator to create a new social media advertising campaign, put in some images, put in information, and what this AI program did, it obviously went out and had a look at what our client does, sort of checked who their competitors were, and it created this entire advertising campaign, which went live, which said, our blur is better than blur. Can you believe it? It's like amazing, and this wasn't the first ad that came out. The first ads were fine, but it started to refine it, and they kind of left it to, keep on developing it. This is easy. Keep doing your thing, AI. And it did, and it's now caused a big problem. So you need to be careful. The next thing where AI will become very important in law firms, certainly, is e-discovery. Now, I mean, this is super sexy stuff. I was amazed at what it can do. We are not at the point where we can use e-discovery yet. I don't think we've quite figured out how we would deal with the confidential information aspects of it. Obviously, you would only use it in a closed system, and you would have to use it in seriously big litigation. So where e-discovery finds application at the moment, particularly is in the US, where in discovery, you get dumped, in litigation, you get dumped with a huge amount of paperwork or emails. And you can use these e-discovery tools to, for example, categorize your documents. Or you can say, list all the documents where there was an exchange of correspondence between party A and B out of the 2 million documents that we received. Or list all the documents in which there is a warranty clause. That kind of thing can be incredibly useful. And instead of spending days and days reading through all the paperwork, I think these e-discovery tools can be incredibly useful. We'll have to see when we get there. And then the last one is for legal research. Now this one, as far as I'm concerned, is the one where it's maybe not such a good CA that you have, okay, the liability CA, because there have been 2 cases already, one in the States that I'm sure a lot of you guys have heard of, where an attorney, whose name was also Stephen, when I read that, I was so disappointed. Different surname. He used an AI bot to prepare a brief, which he presented to court, and it contained 6 references to cases which do not exist, but which in fact suited his case, which I guess also meant that he had a terrible case to start with because AI had to make things up, but still. And in South Africa, there's been a case already in the Johannesburg Regional Court where AI did exactly the same. So super high risk as far as I'm concerned on that particular front for us. So check carefully. So now the question is, 2 years ago, we were standing here and we were all talking about NFTs. Man, non-fungible tokens were hot stuff. Okay, nobody has them anymore, or if you do, they're not worth anything. So is AI going to be the same? Is it just going to fall away? I don't think so. And this particular graph comes from a report which was published on Monday. It's the PwC Top 100 Firms in the UK annual report. And I don't know if you guys can read, it's a bit small, the text, but the 3rd line from the top shows you that the IT support function, this is looking at what the priorities are for law firms from an IT perspective over the next 2 years. And the 3rd line from the top, which is joint second, is to look at implementing Gen AI software and strategies. So super high priority for firms that are, golden circle firms, top 100 in the UK. So the question is then, where do you find these tools? And this is the process that we are going through at the moment. There are so many tools out there. If you hop online and you start searching for AI tools, there are tons. I think you mentioned, and they're good ones and bad ones, yeah. Right? So where do you find them? Well, there are a couple of different places. The first and foremost, the easiest place to find them are from the big players, the Microsofts of the world. And Microsoft Copilot is one such example. It's Microsoft's leading AI, sort of, let's call it a general practitioner AI product. It's not necessarily aimed at law firms. So we've tested it quite a lot, and we found it to be quite useful, but it's not really specific enough to deal with what we want to do in the legal sense, or for litigation, or for trademarks or patents, or whatever the case may be. But it can be a very nice step up from the second category, which would be public available tools, the likes of ChatGPT or Bard, which Google has rebranded Gemini to Bard. Very good tools. I mean, ChatGPT generally does a very good job. But of course, your risk there is that your information is out there. Okay, so we can't use it. Some firms are developing proprietary Gen AI tools, and there's always we're always tempted to do this, because we have very specific requirements. So we develop software in-house, and then as time goes by, we realize that there's a good reason that we became lawyers and we're not software developers, because we take long and scope creep is a real problem. Okay, so some firms are doing this. I think in our case, we would be looking at specialists in the field to provide the products that are specifically meant for us or that we could use. And what we have also seen is that this is not, there's no one-stop shop for this. Copilot, for example, is not going to work for all of our applications. We will probably have to look at different types of AI to deal with contract management on the one side, litigation on the other side, perhaps trademarks as well. That brings me to the third category, which is where our focus is at the moment. And these are Gen AI products that are being created by a company that already have existing tools in the market. So NetDocs AI, NetDocs is the document management system or document repository that we use. And it's a nice, easy fit for us because we already have all of our documents in this database. You don't have to transfer your information to another database and deal with all the gremlins that come with that. So it's a useful one to look at, and a lot of firms, I'll show you in the next slide, are going through this process of saying to their existing software developers, so what do you have? And it's becoming very much like it was, I guess, in the sort of 1995. So I'm showing my age, when it became a thing of, okay, so you're a company, have you got a website yet? Now it's expected. Back then it was, quite a big thing to have a website. Now it's expected, and I think what's going to happen is that software companies are going to have to have AI add-ons. It's going to become critical. And then the last category, which certainly the category that's seeing the most activity at the moment in the legal space, would be new Gen AI products which have been developed for specific tasks. And a couple of the names there, Harvey, Henchman, Case Text, and Spellbook. These are the big programs that are available at the moment. Harvey, Henchman, and Spellbook are all contract management tools specifically. They can do other things, but really what they are good at is managing contracts, drafting contracts, changing clauses in contracts. There are also other aspects to them which could be quite useful. So, for example, if you're in-house and you are managing a vast number of license agreements, you can feed those agreements into these AI modules, and they will review the contracts and identify the next renewal dates for you, for example. I mean, if you're in the retail space and you're managing the licensing arrangements for models who appear in your photographs, in store, or on your brochures, that's a real headache because there are hundreds of them. So it could be very useful from that perspective. Case text is one which is much more focused on the e-discovery process. And yeah, I mean, I mentioned that to you guys. So these are all American though. And we're starting to see in South Africa, the Henchman is used a lot by a lot of the law firms, a lot of the big law firms. We are looking very closely at Harvey at the moment, which also seems to be getting very good application. The question at the moment hanging over these particular items or particular tools is whether or not they will be able to keep up. At the moment, they are all based on large language modules. They all, from a software perspective, doing a really great job, but they don't necessarily have access to a lot of the raw data. And there are large companies, typically old publishing companies that sit with huge amounts of data and that are developing their own AI models. From a practical perspective, they're not nearly as good as these yet, but we are considering whether they may overtake these providers quite soon because they've got access to the data, and that's really what it's all about. Right, so this slide comes from the same PwC report that I mentioned to you. You will see that it indicates in different colors whether firms have already implemented. Sorry, it's very small. Can you guys see it on the screen? Okay. Whether firms have implemented, are implementing, are testing different types of software. And you will see at the top of the list there is Microsoft Copilot. In terms of implementation, it had the highest percentage of respondents had already implemented Copilot, and also the highest percentage of respondents were testing Copilot. And I think it kind of makes sense because, one, it's easy to find. Microsoft, you know where to go look for. You know that it will most probably work with a lot of your existing systems. I mean, competing systems can be a problem in a large organization. And then, of course, backup and support, you would hope, will always be there. One of the challenges we find with Microsoft is that they love to just update stuff. Okay, and then if you've got software which doesn't update with Microsoft, then you end up with problems, having to fix your other software after the fact. What I also found very interesting was and this is now where I needed my specs. This is terrible, guys. The fourth one from the top shows 42% of firms are looking at using AI based on, really, I can't believe I've gotten so blind, Kelly, this is terrible. Oh, looking at existing tools. So looking at finding products like NetDocs AI, which will sit on top of existing tools. So those are really the two that seem to be leading the pack, so to speak. Okay. Right. So then I also thought, let me do a little exercise. I went on to 2 AI products. I used ChatGPT and I also used Copilot. And I asked the question, I said, what are the factors that you need to consider when looking at AI for a law firm? Very interestingly, the answers overlapped to a large extent, as you would expect, but they were not identical. All of the numbers 1 through 11 were all given by ChatGPT. Copilot only gave the ones which are highlighted, which I thought was quite interesting. I mean, Copilot is Microsoft. It was less, it gave fewer responses. Okay, and I didn't give any limitation on the number of responses. And I think Copilot left out some things which might be considered to be obvious, like what are your specific needs? Well, I mean, you would think that you would think of that in advance, but it's a good starting point, right? And then also what Copilot left out was scalability, which I think is incredibly important in large organizations. So don't write off ChatGPT just because it's free. I think it's a very good product. It's just difficult for us to use in our particular case. Right, that's me. Thank you.
On the slide deck here, a round of applause. We've got 10 minutes for questions. It's a huge topic. So I'm going to actually, let's just see what our polls are looking like. If maybe by a show of hands, what they're going to do for the online audience, they're going to show the answers to the polls on the screen. And maybe through a show of hands for question 1. Do you think AI regulation encourages or discourages investment in innovation on the continent in relation to AI? Just quickly, yes, encourages. Okay, discourages. Right, more on the encouragement side, or indifferent, right? Kind of indifferent. So it seems like there's more encouragement. Would you agree with that? Would you say that regulation encourages or discourages for JK?
I would definitely go for encourage. Reason is that I think Africa is in quite a unique space right now where we actually have the ability to leapfrog any legacy system, any legacy country. So I think our growth trajectory, as you said in the beginning, can be exceptionally good on the back of AI. The challenge we have is if you look at the level of education of the average African consumer, the ability for us to exploit and to use data for purposes which they may not necessarily have provided consent to and a whole bunch of other stuff creates a whole bunch of issues. So I do think regulation would need to be encouraged in order to provide a sustainable type of growth curve, something that doesn't go up and then crash in the back.
All right, brilliant. Well, you asked the audience and they agree with you. That's the online troll. Danny, have you got anything to say on that?
Yeah, I'm going to go the opposite, but I agree with what JK said. So I would actually say discourages, but if you look at the country, JK is completely right. For Africa, I think regulation is imperative, but when we're looking at the EU, small startups might not be able to afford to become compliant, and it'll just wipe them out completely because that investment could have gone into investment into the AI, and now they have to invest in regulatory systems that might not even have been applicable if it was there. So yeah, it depends on the country.
Yeah, and I also think it depends probably on the type of data being processed. So there might actually be industries in which it's encouraged and other industries where people are quite indifferent to the pen.
Cool. All right, so next one. Africa has long complained that as a net export of innovation, creativity, and discovery, and that doesn't always get a fair value in exchange. Given that data is the new gold and AI is the new technology, does this create a need for strong regulation of AI in Africa? Related to the first one, let's just have a look there. By show of hands, yes, no. All right, again, yes, there. I'm going to ask the chap in the audience. So you put up your hand for no. Why would you say that?
At the end of the day.
Great. So could work the same as exchange control, have unintended consequences through overregulation. but a good answer. Thank you. Right. What do you think the two most important misuses of AI require regulation as it pertains to Africa or Africans? Right. We've all got access to the screen. The screen, I don't know if the online audience can see the screen, but it's very much in favor of the first answer. Does anyone disagree with that?
I would go with misinformation. If you look at the online meddling in terms of content to drive very specific political agendas, then I would assume that misuse and abuse and misrepresentation might be the biggest. I'm not sure if you guys have actually seen some of these videos where Elon Musk and all these other guys are basically used in these deepfake videos. I mean, it's completely wrong, and it's basically misleading individuals into doing particular things. And we know that there is international interference in social media to drive very specific outcomes. So yeah, I'd go with misrepresentation.
Representation, which was
the last
one. Yeah. All right. Any other comments? It's interesting that the ESG risks, no one's really interested in that. All right, it's not saying no one's really interested, it's just not on a priority list, right? Okay, so moving on. If I mean, one thing maybe Verena can comment on that is IP protection. Falls quite low on the categories.
Is that on?
So what do you think about misuses of AI's intellectual property of Africans?
Oh, you're right. I think it's probably just something that's not necessarily front of mind, and it's very particular to copyright owners that would be more concerned, and therefore not seeing it in those results. Yeah.
So I'm thinking African fashion design, that type of thing, being kind of become part of global fashion without us really, but fine. Just thought I'd ask you that because it did overlap with your talk. Right. If a law firm could guarantee no legal, moral, or ethical risks in deploying an AI solution for a service that enabled you to receive that service cheaper, better, and/or faster, would you trust the outcome? Yes, if I knew it was from a reputable firm. B, only if I knew there was human intervention. No, I don't yet trust AI. So this is number 4.
If I can jump in here, Darren, I think it would depend on the process that the law firm followed to provide those guarantees, right? You would need to do a whole bunch of checks and balances in order to provide the guarantee. On the back of that, I would imagine that a big law firm would have gone through the proper due diligence to deliver that service in order to protect the reputational risk on the back of any negative findings. But yeah, it would depend on quite a whole lot of factors.
What do you think, Stephen?
I mean, I tend to agree. I think it's in I thought there would be far more answers saying, yeah, sure, if I've got a guarantee, I'll go for it. I think it does show that people don't quite trust AI implicitly yet, and rightly so. I think it also hopefully shows that there's still a place for human oversight, because at the end of the day, it needs to remain a tool that we can use, as opposed to the other way around.
Excellent. Any comments from the audience on that? Right, none so far. Last 2 questions, and then anyone in the audience got additional ones. So, do you think the use of copyrighted works to train AI models should be an exception under the Copyright Act, or otherwise be regarded as non-infringing? And I'm Verena and Stephen there are looking for answers there, but let's. Those of you who don't know Stephen, he's a big he's involved with the new copyright amendment bill in detail, but it's a whole different talk on its own. But let's have a look at what the audience says, and I'll ask Verena if she agrees. So the answer is yes. Where are we? Number 5. Gee, it looks pretty equal.
Cool.
What do you think?
Down the middle. Gun to my head, blanket exception, no. I would even venture to my personal opinion, arbitrary deprivation. I think something of a more balanced approach would be justified. So that's not to say there's not scope for an exception or circumstances where an exception could be applicable, but you can't just discount the investment that goes into the creation of some of these copyright protected works. If you take the example of Getty Images, you know, it's a huge investment to build up that database of high quality images. It's an entire business model to simply allow internet scrapers to run over it, you know, gather the content, and then put an AI model in a position to compete directly. It just feels unfair to me.
You want to add to anything, Zed?
Crowding. Whoa. So crowding, it's incredibly difficult for, if we say, for a new music artist to actually make a breakthrough. There's so much competition, human competition out there. So if others can, with a click of a button, create new music, and by the way, this is happening. It is uploaded, you know, every day by the hundreds, sometimes by the thousands. Spotify doesn't know which are human, except for the more well-known people. The same with books. A few years ago, Kindle had a problem when they realized that 87 of their top 100 bestsellers or most read books in the romantic, I think it was a young adult romantic section, were not written by humans. They were actually gibberish. So the thing is, from to use a tool to create creative outputs that actually rely on pre-existing works, like Verena said, that people invested in, that people depend to actually make a living from, is just wrong. And ultimately, in South Africa, just a quick mention of the Copyright Amendment Bill that President Ramaphosa referred to the Constitutional Court last week. This bill contains exceptions that would pretty much make machine learning quite possible without much risk in South Africa. And just as a matter of interest, our lawyers have already received queries from international agencies saying that we are interested to base machine learning. So this is to base operations in South Africa where the ingestion stage would happen. And that in most countries, including the EU under their new EU Act, it's the ingestion stage where you can prove as a right holder that copyright infringement took place. So if you now say that in the ingestion phase, you can do what you want, it creates a different output where you cannot actually say that copyright infringement happens. And in that scenario, you create pretty much a paradise for machine learning in South Africa. But what does that mean for our artists and their ability to actually monetize their works? It puts them in a much worse off position than before. And as Africans, we need to really look out for that. Thank you.
Shortest answer Stephen's ever given. So that's to be congratulated. Thank you, Stephen. Wonderful input.
Darren, can I just quickly
chuck
a question in there, because obviously the answer and stuff is very artist specific. What happens if it's an industry where we actually advance humanity? So if it's something like education or health, what would we then say? Would we actually change our answers to that question? Because in my mind, if something impacts the life of 200 Africans for the better on the back of a copyright like exception, then I would pretty much say yes, go for it. But I do agree on the artists and Spotify and everything else.
You can have an exception, and such exceptions exist in international law in very specific circumstances. So if there isn't a license available, and it's, for instance, for a non-profit or advancement of the human race, then absolutely there could be an exception for that. But if there is a licensing environment under which you could obtain a license from the folks whose data you want, I mean, the phrase garbage in, garbage out was a thing coined by an IBM engineer in the 70s already, knowing that the quality of your AI offering depends on the quality of the data that you put in. So if there isn't a way to get it, yes, maybe. But if there is an existing and thriving licensing environment where you can actually approach another company, say, I want access to your data set for let's negotiate a licensing deal, then you shouldn't just say, I'm doing this for altruistic motive, and therefore I don't need to pay anybody.
Yeah, that's an excellent point. Maybe those models could be explored, but I'm very keen on that.
Yeah. CEO entering the debate on national policy on copyright, man of multiple skills. I'm going to end it there. AI policy, that's just an interesting one. And there, not yet, do not yes and no. Thank you very much for your participation. If you've got questions, everyone here on the panel is going to be available for lunch. I am cognizant of time. Don't want to keep you overly. Thank you very much for attending our Crammer. Feedback is very important, so we look forward to that and enjoy your afternoon.